Item 13. Yes, what do you want? 13, 14, 15. Okay. On the request of Mr. A. Joe, learned counsel appearing for the writ petitioners with this batch of writ petitions made with the consent of the other side. Hearing of these matters stand adjourned till 14th May 2025. Register to list the cases accordingly. Yes. Item number 16, yes. No objection. Mr. Nimawang, learned counsel for the petitioner, appellant, seeks adjournment in this case on the ground that his senior is indisposed. First of all, the prayer is not opposed by Ms. V. Shupre, learned. Your additional senior government advocate, Asa.
Additional AG.
Additional AG, additional advocate general, state of Nagaland, and Mr. So-and-so, learned counsel for the private respondent.
CGC.
And so-and-so, CGC, appearing for the respondents, have not objected to the prayer. Same stands allowed. Let this appeal be listed for hearing again after 3 weeks. After 2 weeks. Okay. Yes.
Appeal commission item number 4.
Item number 4.
Better take out after 2 weeks, my lord.
Any objection?
No.
Mr. You're Mr. Mr. Zetagli, Learner CGC, appearing for the respondents, has prayed for adjournment in this case with a prayer to list the matter again after 2 weeks. Since the prayer for adjournment has not been opposed by the petitioner's counsel, same stands allowed. List the matter accordingly.
Please, Your Lordship. Your Lordship, I beg to mention item number 12.
Item number 12.
Yes, Your Lordship, on behalf of the council for the respondent and Your Lordship. It's my humble prayer that this matter may be listed after 2 weeks, Your Lordship.
You obtained the consent of other side?
Yes.
With the consent of the opposite party, the learned counsel appearing to the respondent numbers 2 and 3 has sought adjournment of hearing of this appeal with a request to post the matter again after 2 weeks. Since the prayer is not opposed, same stands allowed. List the matter accordingly. Yes.
Yes. And Your Lordship, I also beg to mention item number 9.
Yes.
Your Lordship, it can kindly be listed after.
You are appearing for whom?
Appearing for the petitioner.
Petitioner, your name, please?
Be acted.
Ms. V. Anethare, learned counsel for the petitioner. Six, posting of this matter again after a week so as to enable her to obtain updated instruction. Prayer is allowed. This is the matter accordingly. Yes.
That will be the item number 8.
Second one.
I'll be funding my academic.
You are appearing for?
11 days. Zoning law.
Acha, how much time you want?
I'll be funding my academic.
Okay, Mr.
11.
Mr. Yangarwati, learned CGC appearing for the Union of India submits that counter affidavit on behalf of the Union, on behalf of the center will be filed during the course of the day, and therefore this matter be posted again after 10 days. The prayer,
Lordship, it may be listed. For the next division bench, coming Wednesday, Lordship, because the affidavit is being filed.
after a week. Mr.
Don't worry about it. I'm also for the responding in this case, I'm the intervener.
Who is for the petitioner, PIL petitioner? Your Miss L. Soni, learned counsel for the petitioner, is present and does not have any objection to the said prayer. Mr. Joshua Srike, learned counsel for the respondent number 8, posting of this matter again before the next division bench. Prayer is allowed. List the matter accordingly. Yes. Sorry? What is the IA about?
I think this is by the response for the issue of the name from the area of response because this one.
IA has been disposed of.
Yes.
She is saying it has not been disposed of. Register to verify if the IA civil number 59 of 2024 connected with this matter has already been disposed of, and if so, the same be indicated in the cause list. Yes. Any other mention?
For motion, item number 1.
Yeah, please, Lordship. Lordship, by the last order, your Lordship, was giving an instruction to update us to whether there was any extension of the extension of the petition detention, your Lordship. But accordingly, I received an instruction that extension has already been granted, your Lordship. Which was accordingly being received by the petitioner also.
You have received copy of extension.
No, Lordship, no, Lordship. My Lord, I have inquired from the beginning, but however, till now, he did not receive any confirmation. Extension of the Lordship.
So detention order has been extended for another 3 months.
Yes, your Lordship. And this is not being incorporated in the present petition, so.
When you file an affidavit, we'll post it before the next division bench next week.
Okay,
Can you file an affidavit?
okay,
You have to challenge this also. File an additional affidavit,
okay, Lordship.
right? You have received a copy.
No, Lordship, no.
Can you give him a copy?
Lordship, I need to copy.
Right. Miss Livika, learned government advocate, state of Nagaland, has obtained instruction in terms of the order dated 16/4/2025 passed by this court and has produced a copy of the confirmation order dated 16/4/2025 issued by the chief secretary to the government of Nagaland, thereby predicting that the order of detention of the petitioner has been extended for a further period of 3 months with effect from 18/4/2025. Mr. T. Pong, your T. Pongne?
Yes, Lordship.
Learned counsel for the petitioner submits that no copy of such order has been furnished to him till date. In view of the above, Ms. Levika to furnish a copy of the order dated 16/4/2025 to the learned counsel for the petitioner during the course of the day, so as to enable him to file additional affidavit in this matter, full stop. Registry to list this case again before the next division bench.
Your Lordship, can release it after 2 weeks, Your Lordship, because the following week was I'm having some problems.
No, let it come up, then we'll see. Seek an adjournment, let him file it. These are detention matters. Yes,
For admission, item number 2.
so some rule has been under challenge. We have to admit it and post for hearing. Pleadings are complete. Pleadings are complete.
Yes,
When do you want the matter to be heard?
can be next week, Wednesday.
All right. Yes? Yes, you can give it, so. Heard Mr. A. Zohar, learned counsel for the
Petitioner.
writ petitioner, also heard Ms. V. Shukla, learned additional AG, state of Nagaland, appearing for the respondents. It is submitted at the bar that readings are complete in the matter, full stop. Since the provisions of rules are under challenge in this writ petition, the matter would require detailed hearing. As such, I admit the writ petition, since the parties are already represented. No further notice is required to be sent in this case. On the request of learned counsel for both the sides, this
I-
matter be
I
posted.
send the apology, my lord, the day fixing day. On that day, I have the hearing, so may be posted to 21 May then.
On the request of learned counsel for both the sides, register to list this case for final hearing on 21/5/2025.
March of like.
For admission, item number 3.
Yes.
There is a lordship. This matter pertains to appointment of about 1,000 constables in the police department during 2019 to 2021. Lordships are aware that this was a period when the entire world has been struck by COVID-19 pandemic. As many as 13 writ petitions have been filed. Out of the 13 writ petitions, 12 writ petitions pertains to appointment of constables, and 1 writ petition, that is WPC number 317 of 2022, that is concerning to the present appellant, who are the sub-inspectors and UPSI, an armed branch sub-inspector, and the ASIs. There were about 40 respondents, and the grounds of challenge in all the writ petitions were common. That is, the appointments have been made without advertisement. That is an admitted fact. We are also admitting that yes, the appointment has not been done by way of an advertisement. And there are 13 writ petitions, 15 writ petitioners here who are the aspirants and who are looking for the employment. So they have challenged this. So far as the case of constables are concerned, during the course of hearing on 8th of August 2024, this honorable court has passed an order granting permission to the learned advocate general on the submission of the learned advocate general. The respondents were allowed to file additional affidavit because during the course of hearing, there was some point that is with regard to the relaxation in view of many years of service, some amount of relaxation may be given. That was the issue raised during the course of hearing. So this honorable court, learned single judge, was pleased to allow the government to file an additional affidavit in what manner, to what extent you want to give the relaxation to the serving employees. That is pertaining to the constables only, not the sub-inspectors. Now, the affidavit was directed to be filed on or before 20th of August. So incidentally, it was filed one day before, that is on 19th, it was filed. And the matter was heard on 20th August 2024. And the judgment was reserved. The state was represented by the learned advocate general. And in the affidavit itself, the categorical statement of the the respondent was, the state government has taken a decision to advertise the post. That was the concession made by the learned advocate general in the case of the constables. And an affidavit in opposition was also filed in that case, in the case of constables. An additional affidavit was also filed after the learned single judge granted the permission to file additional affidavit seeking the relaxation with regard to the basic qualifications, some criteria in the qualifications. On 20th September 2024, the judgment was delivered by the learned single judge in respect of the constables. After about 6 days, on 26 September 2024, these two cases, which were not included in the first page, was taken up for hearing. One case, that is WPC 317 of 2023, that was pertaining to constable, and our case, the prison appellants, who are the sub-inspectors in the ASIs, are concerned with WPC number 317 of 2023. So in their case, no affidavit in opposition was filed. But during the course of hearing, a pointed query was made by this honorable court whether the judgment passed on 20th September will also cover these two cases. The response from the government side, the additional advocate general appeared, not the advocate general. The earlier case, advocate general was appeared, but on the subsequent date, during the hearing of the present case, has been represented by the learned additional advocate general, and a concession was made that yes, there is no difference in essence, there is no difference. Therefore, the judgment passed in the constable case will also cover this case. That was the concession made. Again, the present appellants were also represented by their counsel, and the counsel has incidentally also considered to the same fact that yes, this will cover our case as well. So I don't blame the learned single judge, because on the concession given in the course of hearing by the counsels, the learned single judge has relied on the judgment which was passed on 20th September 2024. The direction of this honorable court was the appointments were quashed and set aside, and the state respondents were directed to advertise the post within a period of 6 months. And in such process, the petitioner, the respondents should be allowed to appear in that review.
By relaxing the age.
Yes. By relaxing
What has
the
happened to
age,
that process? 6 months?
no relaxation has been given with regard to the basic qualification and criteria. That is one. Coming to the present case, where another case of constable was also included, which was heard together, the two cases which was left out with the first page, where no affidavit has been filed by the sub-inspectors. There was a serious communication gap in this particular case because out of the 40 respondents, there were 2 respondents who were appointed on the basis of an advertisement. But petitioners thought it that they were also appointed without any advertisement. So they were implemented as party respondents along with the present appellants. So during the hearing also, it was not pointed out by the counsel of the present appellants who were the respondents in
Alright,
that
so
case.
now at this stage, what are you asking for?
Since no affidavit in opposition has been filed in our case, at least we should be given an opportunity to file affidavit in opposition and hear the matter afresh by the learned
All right,
judge.
you may have a point in that, you may have a point. But there are 2 issues here which has to be dealt with. First of all, as you yourself have said, that the counsel representing your clients has also considered before the court that this matter is covered. Therefore, the judgment is without any blemish insofar as this part is concerned. That is what you are also saying. In other words, it's a consent order, right?
Lordship,
So-
in that,
No, I'm just coming to it.
Lordship, yes.
So is it not the proper course that you seek a review of the judgment and point out and say that you segregate our matter and hear it? Because single judge has to hear the matter. Is it not? Just think
Yes,
about it.
I agree.
Because on what ground do we set aside?
That is one approach. But lordships are well aware, in a review, the grounds which is very limited, it will be as court as asking them.
No.
So
Review is only to that extent that this concession was made erroneously. So that is an error apparent.
that is one of the points.
Yes, if these 2 writ petition or this writ petition is not covered by the judgment, then it has to be heard and decided on merit.
Lordship,
That decision has to be given by the single judge,
lordship,
not by the division bench.
yes, lordship,
Is it not?
yes.
So the first recourse has to be that you have to point it out to the judge who has passed the order, saying that you please recall the order insofar as disposal is concerned and restore the writ petition, hear it on merit. If the judge refuses to do it for any reason, that is the time you can approach the appellate court. Today, what order the appellate court will, we cannot set aside the judgment.
What I'm trying to project is, since there was a serious communication gap, because the clients have already informed the counsel to file the affidavit in opposition, which was not filed.
No, I understand that. What I'm saying is, why don't you point it out before the single judge? Single
And-
judge is the right forum to deal with it. If the sing-
Lordships are well aware that for the lapses on the part of the counsel, the litigant, the client should not be prejudiced.
All right, we'll admit it and post it for hearing then, but then this problem will come. This is a consent order. Consent has been given erroneously, has to be told to the single judge first. You cannot change that position in the writ appellate court. That law is also settled. That will create problems for your client.
Lordship, that is also one approach. I would also,
That is the only approach. There is no
Yes.
other approach possible here. Because the
Yes.
consent given rightly or wrongly, it has to be told before the judge concerned
Lordship,
that there was a communication gap and this is not covered. If the judge says yes, then your matter will be heard. If judge says no, then you can assail the order before the court saying that this is an erroneous finding.
Lordship,
So you decide the writ petition.
Lordship,
Then we will decide the writ petition in the division bench. But straight away doing it, I have my doubts. Because nowadays matters are taken to Supreme Court and this consent, appeal against consent order like this will be very difficult. That's what I'm pointing at. You
understand.
have a point. Some grievance is recognizable. Your client's grievance, we are recognizing it. Whether they succeed or not ultimately is another matter. But in these circumstances, the only recourse permissible is to point it out to the judge concerned that there was a mistake on our part. This is not a mistake by the court, but by us.
For to clarify that, Lordship, a review has been filed by the two respondents, and review has been allowed also. In rectifying that. But that was only in respect of two persons.
Rest, you file a review for the others. That's what I'm saying. That is the best and only way available to you. You don't have any other way. Otherwise, this matter will go into very cantankerous legal issues. And if there is an objection, we'll keep hearing the matter. We'll delay the process. You can
Exactly.
say this is the advice given to the appellants. We can hear it, but then they'll raise these points. Court will have to deal with it. And then once these judgments are shown that consent order, no appeal lies. Your appeal will be dismissed, then what do? You have to go to Supreme Court. Then come back to the single judge. Why do you want to do it?
So far as constables are concerned, they have approached the ethics court. But then ethics court has dismissed on the ground that without exhausting the remedy in the division bench, why you have come, so that was dismissed. And accordingly, appeal has been filed and it's pending in the principal seat. But that is in respect of the constables.
Constable. But is there any stay order in that appeal?
No, it is not yet listed for admission. Lord.
Okay, see, that is why I am pointing it out that even if substantially you may have a grievance, but in legal matters, unless the path is correct, it creates multiple obstacles for the party.
Lordship.
And the court of law is technical, it has to go technically, is it not? That is why it is a legal battle. So you think about it, Mr. Jamil, perhaps that will be better for your plan.
I would agree, accept Lordship, even for the review.
Think about it,
Lordship.
examine it. Because we'll admit it.
Lordship.
And then matter will remain pending, then in the final stage, these pleas are raised, and they'll say you have not exhausted relief. File, the matter will get delayed.
Lordship, I have.
Why don't you wait for your turn and finish it with it? Please, we'll hear you.
Lordship, let me think over on that later.
If you want to argue today also, no problem, we'll hear you. But I am just cutting the long matter short.
I understand.
After three hours of hearing, telling it to you, and in 3 minutes telling, I have read your judgment. I have read it.
Let me take over.
What has happened 6 months time given, has it been
It's
complied?
already expired, Lordship.
They have,
Lordship, extension has been granted in respect of the constable. 4 months' time has been granted. Lordship, case was there.
yes, you wanted to say something? You are appearing for?
I'm for the respondents.
Who are the petitioners?
Six to 20. We were the writ petitioners, Lordship.
So what do you have to
Here,
say?
my humble submission before this honorable court is that on 21/1/2025, Lordship, similar case, the Supreme Court has already dismissed the constable's case. Now that is one aspect where Lordship will kindly
No, that was dismissed for availing alternative remedy, appellate remedy.
here it says that was not recorded. The Supreme Court in its order says we are not inclined to interfere with the impugned judgment and order passed by the High Court. The special leave petition are accordingly dismissed.
That is a dismissal and limine.
But it's not reflected here in the, so Lordship, where is the question of not approaching the division bench and coming, those are
That is
not,
in respect of the constables.
So
No,
after dismissal of SLP, you have now filed appeal in the High Court.
That is the constables, they may have filed. It is there on record.
So they have filed.
Yes, they have filed and it's pending. Before the principal.
so that is one aspect, and Lordship, in your wisdom knows that Article 13 of the Constitution of India, that is very clear. It says that laws inconsistent with or in derogation of the fundamental rights. Here, our only object in filing this writ petition is that whether there is an advertisement or not. That's all, nothing more, nothing less. whether there is an advertisement, it is an admitted fact that they have pleaded before this honorable court that there was no advertisement. And what is there to argue further? The law is very clear, Lordship. It's the law of the land. So where is the question of again dealing? They have also taken so much time. If the case is already covered in January, but every time it comes up, they will take time. Just a delaying tactics. So, Lordship, this because of this pending, even the constable case, they were helping against of that some changes will come, and they are yet to process for advertisement also. There is some slight indication that because of pending of this case, even the constable case, it is a similarly situated case only for the year of 2018-19, Lordship, appointed without advertisement. So it's not an isolated case, Lordship, and the law is very clear. Again, if they go for review or whatever, can it change the circumstances of this case, Lordship? Can it change the circumstances of the law of the land? So, Lordship, is very clear that 13 is very clear. All laws enforcing the territory of India immediately before the commencement of this constitution, insofar as they are inconsistent with the provision of this part, shall, to the extent of such inconsistency, be void. Also, Lordship, Article 141 is very clear. It says, law declared by the Supreme Court to be binding on all courts. The law declared by the Supreme Court shall be binding on all courts within the territory of India. And Lordship, before this honorable court, in my Lordship's wisdom, even if they go for review or hear the fresh.
That we can't say, whether if they go, what will happen, that can't be said, but in any case, what do you want to do? If you pass an order and it goes against you, then your review is closed.
That's my Lordship.
So your only option is if you want to withdraw, you can withdraw. That is another matter.
Lordship, I also have Supreme Court cases where.
You cannot stop him from withdrawing the appeal if he wants. That you cannot stop, is it not? It is
Let
up
me
to him.
get instructions from my client and then. a
Four,
short time
four,
will be-
4 months extension has been granted.
Lordship.
No, that is in respect
But
of-
that is only in respect of a recruitment process. Otherwise, their 6 months has not been extended.
All right, so
by this honorable
there is
court.
no stay order in this case.
Lordship, there is a
No.
status quo order. NDC 13/11/2024.
That status quo order,
That has been extended by another order that is 27/11/2024. First order will be 13/11/2024. The status quo order has been passed.
that is the
What's
reason
the-
why the extension
And
has been
Lordship,
coming this long.
And that was again, there is a subsequent order on 27/11. Until further orders.
All right. Yes.
On
what
my
else?
part, it is very clear, Lordship. My case is that since it is a backdoor appointment and nothing can change the circumstances of their position. Lordship, I leave it to my Lordship's judicious mind.
No step is taken, this for score in the page. Also, this council for documents also arrangements is made. Taking advantage of this, that is great. We are still continuing this. In spite of the other possible elections. Give an opportunity to assess it.
Anybody from the government?
Earlier, 6 months' time was granted to implement the honorable court's order. However, due to certain procedural exercises, we prayed for 4 months' time to implement the honorable court's order. Judgment and order,
4 months will expire when?
July 1.
This July.
Yes, ma'am. So we are ready to implement the honorable court's judgment.
That is in respect of the constable's lordship.
Constables and this case is all the same coordinate bench
We have
government.
understood, you say.
Yes,
We have
Lordship.
understood.
Lordship.
Yes, what do you want to do? Argue it on merit today?
Yes, Lord.
You are pressing this appeal on merit.
I have two options, Lord.
Hmm.
To take over and
No, no,
on
not
filing
take
a
over.
review.
To withdraw and file a review or argue this matter on merit today.
or withdrawal of the
Thinking,
review,
thinking is not an option.
or withdrawal of the.
Not for a eminent counsel like Mr. Jamil, senior counsel like
No,
Mr. Jamil.
I don't accept that, Lord.
Yes, yes, We know what is good. Mr. Jamil, see, there are hopes and expectations from both sides. The ground on which you have urged, we have already disclosed. Nowadays, the courts are very interactive. We could have heard you and silently passed the order. But we don't mean to cause any prejudice to any side. So on this ground, you will not succeed in the appeal. So you are either getting a dismissal today, which will close the doors, or you withdraw and file a review on this point and then see what happens.
Lordship, that's, well, Lord, in order to withdraw, let me get instructions from my client. So 1 or 2 weeks time, Lordship may grant. Thereafter, for withdrawal, it will not be a difficult job, I believe.
I take down. Mr. C.T. Zamir, Learned Senior Counsel appearing for the writ appellant, seeks 1 week's time to seek instruction from his client as to whether the writ appeal deserves to be withdrawn with liberty to file review petition against the order of the learned civil judge. Mr. Additional AG, State of Nagaland is present for the official respondents. Number 1. Official respondent number 1. Mr. P. Jamil. You also additional AG? 2 to 5. And Miss Z. Zimomi, Learned Counsel for the respondent
6
number
to 20.
6 to 20 are present. Time as prayed for by the appellant's counsel is granted. It is, however, made clear that no further adjournment on the same ground will be granted to the appellants on the next date fixed. Since a status quo order is operating in this case, it will be open to the respondents to press for vacating the order of status quo on the next date fixed if
Yes.
advised.
Obliged.
For admission, item number 5.
Because Lordship, Lordship, there is a delay of 97 days. If counted from the day of passing of the judgment,
Yeah, but notice has been issued, but you have
they have entered agreements, Your Lordship.
you have
And for the
entered-
respondent
Yes.
number 1, the lordship. However, we are yet to file our backup number, lordship.
So delay of how many days?
Lordship, 97 days, if it is counted from the date of passing of the judgment, but 39 days, 39 days if it is counted from the date of passing of the Honorable Supreme Court order, Your Lordship. So there is a delay of 97 Your
So you
Lordship.
want to file objection, we'll dispose of this matter, hear the appeal on merit.
Yes.
Yes, your lordship, with respect to the delay, we will not be filing on any objection, your lordship.
All right. Heard Ms. V. Shukri, Learned Additional AG, State of Nagaland, appearing for the applicants. Ms.
V. Terry.
V. Terry, Learned Counsel is present on behalf of the respondent numbers 1 and 2. You are for?
For the respondent number 2, standing counsel, Accountant General Office,
Respondent number 1, Mr.
Joshua Lordship.
Joshua, Learned Counsel is present for the respondent number 2. This IA has been filed by the applicants seeking condonation of delay of 97 days in preferring the connected appeal. Full stop. According to the petition, according to the applicants, the delay in filing the appeal would be 39 days if record from the date of passing the judgment and order dated 15/1/2025 by the Honorable Supreme Court of India. Full stop. We have perused the explanation for delay furnished in the application. The learned counsel for the respondents submit that they do not have any instruction to file objection opposing the prayer for condonation of delay. In view of the above and considering the explanation furnished in the application, we are of the considered opinion that the present is a fit case where the delay of 97 days deserves to be condoned and the connected appeal be heard on merit. Full stop. Delay is accordingly condoned. The registry will list the writ appeal for admission before the next division bench. Highest stands disposed of.
Okay, much better.
There are other matters.
Yes, a similar matter, but the delay is different, your lordship, 248 days.
Same parties.
Same parties, your lordship, yes,
Only the number of days of delay is different.
different, your lordship. The petitioner, the respondent's name is also different, your lordship, but the council are same.
And in all cases, she is for respondent number one and he is for respondent.
Yes, lordship, yes,
Then we'll change the days of delay and.
lordship, lordship.
And every case, Supreme Court judgment.
Yes, every case, lordship, yes.
Date to file about.
Mm.
Item
Much-
number, which are the matters? Item
6 and 7, your lordship,
6 and 7.
yes.
Constable and Silo, delay to demand. Alternative 37 or direct.
Your lordship, in the meantime, I may be allowed to file affidavit in the position, your lordship.
In the,
In both the writ appeal as well as in the IA for stay, your lordship.
it will be listed then see.
Lordship, much obliged.
Disposed of. 6 and 7. Disposed of. Yes. Next matter, please.
For hearing, item numbers 10 and 11.
Manoj, I'm appearing for the appellants.
What is this?
Manoj, this is a case, Manoj, arising out of the impugned order of the learned single judge, Manoj, whereby, can your lordship hear me?
Yes.
Yes. So, Manoj, this is an order, Manoj, arising out of the order of the honorable single judge, Manoj. Your lordship can't hear me.
No.
Manoj, can I just be allowed to attach on another system, Manoj?
This is for final hearing today.
Yes, Manoj.
Final hearing, you want to do it through DC?
Manoj, I have not too much choice.
No,
But yes,
I
Manoj.
understand the difficulties, but it may be a little difficult.
Manoj, it may be difficult for me to be.
Number one, the sound is not coming in.
That's it. Manoj,
Final hearing matters.
Manoj, I'm just trying from my system.
Can you hear? I cannot hear. Can everybody hear the sound?
Can your lordship hear me?
Just put that off.
It's not clear.
Can your lordship hear me on this system, Manoj?
Yes, so, what is to be done? Other councils are present physically?
There are two appellants. I think only one appellant is here, CGC so far.
Where is the other appellant? The two matters are connected, tagged up.
Yes, connected.
Yes, your lordship. Lordship, I'm appearing on behalf of Manish Singhvi.
On behalf of,
Manish Singhvi.
so where is he? He's appearing.
Yeah, he will come on my, through
Union,
PC only.
Union government is also not here.
So what is to be done? Tell us.
So, Manoj, the second appeal, Manoj, has only been tagged on. Ours was the primary appeal, Manoj. the pleadings are complete, my lords. Ultimately, my lords, it's in a sense a small issue. The finding of the learned single judge is, my lords, that the notification that was issued was without authority.
I must tell you this, for some personal reason, I'm not comfortable hearing final hearing matters to BC, particularly when the quality here is very, very poor.
I understand, my lords.
You may have your own difficulties.
Yes.
The next division benchmark.
So, my lords, if your lordship is desiring a physical appearance, my lords, may I, my lords, if your lordship could just for a moment, my lords, give me 10 minutes and pass over the matter, my lords. I'll just consult it is correct, my lords. I can't hear your lordships very well myself.
Lot of problems with the audio here, and then
Yes.
it's problematic to hear these matters to BC, particularly when the infrastructure is poor.
My lords, in fact, on the last few hearings, it was quite all right, my lords. Today is not the best, I know, my lords. So I'm just wondering what to do, my lords. Could we possibly, my lords, subject to your lordship, my lords, try it on the next Wednesday, my lords? And if that doesn't work, my lords, then I'll find some time and see what I can do.
We understand, we appreciate your difficulties.
Yes.
But
So,
then
my lords, can we kindly try next Wednesday? I know your lordship takes up these matters on Wednesday, and we try it that day, my lords. And if it doesn't work, my lords, I'll then find some occasion. Sorry. So not next Wednesday, my lords, next Thursday.
Lordship, I have some engagement on that day, if I may be accommodated. If a suggested date may be May 14th, Lordship.
So, my lords, one possible date when your lordship can allow us, my lords, to again try is the 7th virtually. And if, my lords, that date is not successful, my lords, then I will see what I can do to find the time, my lords.
7th of May, is it?
7th of May, my lord. Yes, my lord.
Okay, we are 14th.
The 14th, somebody has a problem.
That was my humble suggestion, Lordship.
You want
I'll adjust accordingly, if that is the case.
7th, you have a difficulty?
so your lordship may see 7th or 14th, my lords, either way.
14 May, Lordship.
14th May, my lords. I'm grateful, my lords.
Everybody agrees, 14th May.
I'm grateful.
Ask the registry to set up proper VC facilities.
So grateful, my lords. So grateful for that.
With this, I don't know. whether any-
My lords, we'll take it one day at a time, my lords.
All right.
Of course, if it doesn't work, my lords, for any reason, and your lordship has difficulty. I can't hear you.
It's present through RBC on behalf of the appellant in item number 10. Who is appearing for the appellant in item number 11?
Manish Singhvi.
Is he present?
My lord, senior advocate Manish Singhvi appears in the matter.
That's right, but is he present today?
Yeah, he was present. He was in the queue.
Record his name, if he is somewhere else. Who is appearing? Are you appearing? Who is appearing in this case? On behalf of the appellant in item 11?
Yes, my lord.
So and so is present for the appellant in item 11 on the request of, however, due to who's for the respondents, can you give a list?
Yes, we could provide.
Due to the poor audio quality, final hearing of this matter through RBC did not be possible. Moreover, the learned CBC representing the Union of India is also not present before the court. The view of the above. Let this sentence be listed again for hearing on 14/5/2025 as fixed items.
Can't hear anything.
14/5, does it suit you, Ms. Anand?
Most grateful, my lords.
14/5.
14th.
RBC, there's no view here, hardly anything. All right, you check it up. This is not what is acceptable. All right, next matters, please.
What?
For hearing, item number 17.
Mr. Lordship. Lordship, here the writ petitioner. He retired on 28/2/2005 as Registrar Gauhati High Court, Kohima Bench, Your Lordship.
Who's for the respondent?
The respondent is around, Your Lordship.
NK Louis Kham,
Yes, Your Lordship.
be in the court?
Yes, my friend has gone to call him.
Yes.
So here, Your Lordship, the petitioner, he retired from service as Registrar Gauhati High Court on 28/2/2005. His last paid run, Your Lordship, this is very important. His last paid run was 31,350. 31,350 in the pay scale of 16,400 to 20,900, Your Lordship.
Yes.
And at the time of his, he was getting a pension of 23,650. 23,650, Your Lordship. Now, Your Lordship, I may take you to page 24. This is the office memorandum, Your Lordship, page 49, Your Lordship.
No, first you take us to the judgment.
Oh, Lordship. The judgment, Lordship, it will start from 145, Your Lordship. The judgment is page 108. Page 108, dated 10/6/2024. 108.
There is no pagination. You have not paginated.
My apology, Your Lordship.
Where is the judgment, page number?
108, Your Lordship. If there's no page, then it will be in the last, Lordship, in the last.
Yes.
My apology, Your Lordship.
Paginated.
Lordship, it will be in 145 page. 145. Lordship, para 47. Thus, it is well settled that right to receive pension is a constitutional right. And drawing premises from the illuminating discourse, it can be held that this right to receive pension also encompasses the right of the petitioner to receive the appropriate quantum of pension as per his entitlement. And this is being denied to the petitioner in the case in hand. That being so, any attempt to withhold or curtail the legitimate entitlement of the petitioner based solely on administrative direction would be contrary to the constitutional mandate, and consequently the same would be unconstitutional. 48. In the result, I find sufficient merit in this petition, and accordingly the same stands allowed. By amendments of this court, the respondent number 3 and 4 are directed to refix the pension entitlements of the petitioner to 50% of the revised basis scale of pay of rupees 54,600, corresponding to pre-revised pay scale from which the petitioner had retired in terms of the provision of sub-rule 1E, 5 of rules 19 of the Nagaland Services Revision of Pay Rules 2010, with effect from 01/4/2010 to 31/12/2017, as per table 20 of Annexure 3 of the ROP Rules 2010 and Finance Department OM dated 5/5/2017. 49. The petitioner shall submit a certified copy of this judgment and order within a week from today before the respondent authority. Thereafter, within a period of 3 months from the date of production or certified copy of this judgment and order, the respondent authorities shall carry out the entire exercise. It is further provided that in the event of failing to carry out the exercise within the stipulated period, the accrued sum shall carry interest at 9% per annum till realization. In awarding the interest, this court derived authority from a decision of Honorable Supreme Court in Mahindra Nath Sharma Supra. The party have to bear the cost. So, Your Lordship, from here, there is a clear perversity, Your Lordship. It is the state who has to pay pay or refix the pension to the petitioner. But the learned single judge has directed the AG to refix, Lordship. Yes. Yes. So, Your Lordship, from here itself, there is a perversity we have found. So, though the direction was to the AG, it is the state, so the state has filed an appeal before the Lordship. Lordship, now I may take you to page the OM 49.
So you refix it, then we'll clarify it with the
No, Your Lordship, we have refixed his salary or his pension. Earlier, he was getting 23,650. And in view of the OM 2017, we had enhanced his salary, enhanced his pension, and he was given 24,750. That is the exact fixation, Your Lordship, as per the table 20, Your Lordship. But erroneously, the learned single judge has directed us to refit as per the revised pay scale, Your Lordship. As per the OM, it has to be revised as per the pre-revised, Your Lordship. 50% of the pre-revised pay scale from which the petitioner had retired. So, Lordship, page 49, this OM. Otherwise, because of this OM, the petitioner is entitled for his enhancement of his pension, Your Lordship, up to 50% of the minimum, Your Lordship. Minimum of pay in the pay band and the grade pay corresponding to the pre-revised pay scale.
Let us read the judgment. Yes,
Lordship.
from 109.
Page 126, para 16, we can write it from here.
No, just a minute, let me just go through the facts. So two issues. First, according to the petitioner, his last pay, he had drawn the highest pay scale of 20,900 at the time of his retirement. And his basic and his salary gross emoluments were 31,350.
Lordship, yes.
Now, according to him, this pay scale corresponds to fitment table 20, that is 54,600.
That is the maximum.
That is
Lordship.
the maximum.
Yes,
Because
he is
he is
asking for the maximum.
maximum.
But as per the OM, it has to be calculated from the minimum, Lordship. So, Lordship, the OM, I'll take you to the OM, Lordship, even in the
No,
judgment.
but
also, the OM has-
there are judgments of Supreme Court on how the fitment table is to be implemented, High Court also. You have those judgments.
The Lordship, as per the figment table, the ready reckoner we have prepared, Your Lordship.
No. How the fitment table is to be implemented.
Yes.
There are division bench, Gauhati High Court judgments and Supreme Court judgments.
Mm.
Do you have those judgments?
Lordship, I don't have Your Lordship.
So that is the point here.
No, but Your Lordship, because of the OEM, the petitioner is entitled to enhance his salary, pension to 50%. Lordship, and the OEM clearly says that it has to be from the minimum of the pre-revised, scale pay from which the petitioner retired, Your Lordship.
That's correct, but these judgments lay down what is the correct approach. If the OM is not in accordance with the judgment, then the OM will be of no relevance. That is why.
Your Lordship, maybe a lot of the revision of pension, Your Lordship. This is not the pay revision, Your Lordship, because the petitioner had already retired. It's a pension revision, Your Lordship.
That's what I'm saying. So whether any, there is the order of 5/2/2025 in this appeal. Where a direction,
I've already filed my affidavit, Your Lordship.
additional affidavit has been.
Yes, already filed, Lordship.
You have received the copy?
Yes.
Any response is filed from your side? Or it's not required?
Actually, it's just the clarification part, my lord.
Hmm.
How the OM has been this thing issued. My lord, here actually the issue before not a single bench was there. Whether my pension benefit should be fixed at the minimum or the maximum, from which I retired. In the pre-revised.
Because you ended up in the highest
Yes,
level of the
yes.
previous,
Yes,
so your fitment table will pertain to highest level of the
yes,
next.
that is
revised.
the issue, my lord.
And government says no, even if you have reached at the highest level, it will be at the lowest level of the corresponding.
Yes.
No,
pay.
my lord, yes. My lord,
That is
before
your
approach,
Yes, Lordship.
before
yes.
approaching this court, my lord, I have represented to the authority.
These
And
are all
authority there in support of me.
irrelevant issues. This question has been answered in a number of judgments of the Supreme Court.
So my lord, the fact is that the responding authority, that is the finance department, they agreed to my claim. Only when this was, the direction given by the authority was not implemented, then only I approached before this order book. That is the issue, my lord, and that has been clearly reflected, considered by the single judge.
My case, Your Lordship, before this court is for fixation of pension only, not for fixation of pay, Lordship. The 2010 ROP rule does not cover the petitioner because he had already retired. It is only by the OEM, Your Lordship. We have implemented the
Where is
government of
OM? Let
India.
us see OM.
Page 49, Lordship. Page 49. Page 49. Subject, implementation of the decision of the government of India, revision of pension, family pension of pre-2008 pensioners, family pensioners. The undersigned is directed to refer to the subject cited above and to convey the approval of the government of Nagaland to adopt the decision of the government of India in the following manner. 1. The existing provision under sub-rule 1 of Rule 19 of Nagaland Services ROP Rules 2010 is modified as follows. 1. The pension, family pension of pre-16-2008 pensioners, family pensioners as revised with effect from 1/6/2008 in terms of sub-rule 1 of Rule 19 of Nagaland Services ROP Rules 2010 as notified by the Finance Department via such and such dated 10/8/2010 as amended from time to time shall be further stepped up to 50%, 30% as the case may be of the sum of minimum of pay, Lordship. Sum of minimum of pay in the pay band and the grade pay corresponding to the pre-revised pay scale from which the pensioner had retired as arrived at with reference to the fitment table annexed as Annexure 3 to the Nagaland Services ROP Rule 2010, notified via such and such. The effective date for this modification shall be 1/6/2013. By this OEM, the effective date is 1/6/2013. But Lordship, the next page, page 50. The effective date is to be on 1/4/2010, Lordship. Page 50. The type copy is at 52. Lordship, the date of Roman 1, the date of implementation for revision of the pension, family pension shall be effective from 1/4/2010, Lordship. Then point 2. A ready reckoner indicating minimum pension, family pension of pre-16/2008 pensioners, family pensioner for post-caring correspondent to pay band and grade pay is indicated at Annexure 1. So page 51 is the ready reckoner, Lordship. That is at table S20, Your Lordship. Here the scale P is 16,400, 500 to 20,900 in the pay band of 4. The revised is 37,400 to 67,000. The grade pay is 9,900 and the sum of minimum of pay, Lordship, will be 49,590 and the minimum pension will be 24,795. So accordingly, Your Lordship, we have revised the petitioner's pension to and step up to 24,795, Your Lordship. We have correctly stepped up his pension, Your Lordship.
So how this part has been dealt with by the learned single judge?
The learned single judge, though he has mentioned that the OEM has to be, the calculation has to be as per the pre-revised scale of pay. But in his direction, he has directed us, Lordship, that is at page 145, para 48. Para 48. By amendments of this code, the respondents are directed to refix the pension entitlement of the petitioner to 50% of the revised basic scale of pay of 54,600. Again, he has made a erroneous conclusion corresponding to pre-revised pay scale again, Lordship, from which the petitioner had retired.
So where from this 54,600 figure comes?
Okay, Lordship, that is at page. Page 96, Your Lordship. This is the ROP, Your Lordship. Ready reckoner of fixation of pay. Page 96.
So you are saying fixation of pay and fixation of pension are
It's different, yes, Lordship.
So any authority on that in that particular any
Lordship, I have no authority, but it's very clear because the ROP 2010 came into effect after the petitioner retired. So when the petitioner retired, how could ROP 2010 be applicable to him? for fixation of pay. Your Lordship, here, page 96, this is the reckoner for fixation of pay under Nagaland Services Provision of Pay Rules. Existing pay scale S20, that is 16,400 to 20,900. And the revised pay band is 37,400 to 67,000, Your Lordship. So, Lordship, if you see the last table, the first table, the last one, the last line column.
Has the petitioner challenged this?
OEM, no, he has no job. Because of the OEM, his pension has to be stepped up, Lordship. Yes. Because of the OEM, he got the benefit. So he's not challenging the OEM, Your Lordship. If he challenged, he would not get the benefit, Lordship.
What else?
So, Your Lordship, so there is a clear perversity in the learned single judgment because he has directed us to refix the pension at the highest basic pay.
As per the ROP rules.
As per the ROP rules,
But that
Lordship.
is applicable for people in service.
Yes, only in service, not the retiree, not the pensioners, Lordship. It has to be as per the minimum, Your Lordship. As per the OM.
I'm the AG, respondent, the direction was given to me, Lordship. You refix. Lordship, I'm not the authority. And even judgment of the single bench, Lordship, at paragraph 31. The single bench has made it very clear regarding my role, Lordship. May I kindly come to paragraph 31, Lordship, page 135. Page 135, Lordship. I will belong to paragraph 31, Lordship.
Yes.
Admittedly, respondent number 3 and 4 are not pension sanctioning authority. Lordship, this is very important. We are not pension sanctioning authority, but a pension authorizing agency. So how can a direction be given to me, Lordship? Lordship, the manner in which the single bench has made the observation in the last paragraph, which my learned friends referred to, Lordship. Lordship, that has been reiterated again in paragraph 33 again, page 136 again. Page 136, Lordship, again. Lordship, this one, page 136, paragraph 33, the last paragraph, Lordship. 33. The argument so advanced by Mr. N. Mosey is unsustainable in view of the fact that the respondent and the tribunal are only pension authorizing agency. The pension sanctioning authority is the respondent number 1 and 2, conflicting. No, Lordship, in support of the submission made by my learned friend, as far as the implementation of ROP 10 is concerned. The ROP 10 2010 came to effect from 1st June 2018. Lordship, I have made a statement in my affidavit, Lordship. Lordship, may kindly come to my affidavit at page 75. 74 is my affidavit, Lordship, and I share 3 of the affidavit memo, Lordship. Page 75, Lordship. Lordship, may kindly come to page 75, paragraph 5 of my affidavit. This is affidavit filed by the respondent number 3 and 4, Lordship.
Yes.
That we got a statement made in paragraph 3 of the petition. The answering department denies the same for the fact that the Nagaland Services Revision of Pay Rules 2010, herein of referred to as the rule of 2010, has come into force on the forenoon of 1st June 2008. That is much after the petitioner retired from service on 28 June 2005. Lordship, this is very important. He retired on 28 February 2005. And the RP of 2010 came into effect from 1st June 2018.
8, Lordship, matter 8. So his category falls under the pension, not in service. So now coming back to the OM.
No, how can ROP of 2010 come into effect from 2008?
Lordship, that's a decision of the government.
The rate of ROP implementation would be 1/4/2010, Lordship. 2010. That is the date of the revision of pension will be effective. The implementation of the ROP 2010 and not as mentioned above, that is at page 50. That is the OM, we have to make it clear.
Yes.
Page 50, your Lordship.
No, Lordship, based on that, Lordship, the OM of 2017, 9/5/2017. Page 49, 5/5/2017, Lordship, page 49 of the appeal memo. The clause 1, Lordship, which my learned friend has already read, Lordship. Since he falls under the pension category, Lordship. Now this is how the fixation has been done. So, Lordship, I would just like to mention the paragraph 1, clause 1, Lordship. The pension, family pension of pre-16/2008, which has been rectified to 1. So he comes under the pension category, not in service, because he has retired much prior to the 2010 ROP case. So the learner single has overlooked the OM, Lordship. And as rightly put it by Lordships, the pension has never challenged the OM, firstly. Secondly, they have not challenged the fixation that was done, and we have issued the authority. Lordship, you kindly see the page number 46, annexure A of the appeal memo, Lordship. The authority that has been given. This has been done on the basis of that OM, Lordship. And page 47. The two authority that have been issued by the Office of the Accountant. They have not challenged where the fixation has been done. This is not under challenge. This is how he's getting his pension. He has never challenged. And like the very pointed out, Lordship, if he has challenged the OM, it's all benefit will go. He has got benefit on the basis of this OM.
Okay, lastly, we have correctly revised his pension, your Lordship. We have correctly revised his pension from 23,650 to 24,795. So that is the correct as per the OM, your Lordship.
So presently, how much she's getting?
More than 60, will be 63,000 something, your Lordship. But
So pension has been refixed at 24,795. As per
yes,
the
yes, yes,
statement table.
yes, yes.
And
This
the-
is for the period of okay. From 1/4/2010 to 31/12/2017, your Lordship.
Now what is his gross pension? presently?
Now,
Now, my lord, since the appellate has come with a new plea, I think I'll be prepared to file a petition. But now I'm doing the apex scale pension. The 70,250
Lordship, that will be
as per the latest.
Let her finish, then we'll get.
Lordship, this is the page 85. This is the Accountant General, page 85. This office has revised the pension of Sri Shari Ralim, retired registrar, as per the ready reckoner serial number 20 of annexure 3 of Government of Nagaland, OM dated 5/5/2017, by this office authority number dated 18/4/2018 for an amount of rupees 24,795 with effect from 1/6/2013 as per the ROP 7 rule. His basic pension is rupees 63,723 with effect from 1/1/2018. Your Lordship. His pension, Your Lordship. The one which the petitioner is approaching this court is only for the period of 2010 to 2017, Your Lordship. He has no grievance for the other period. So if we enhance, Your Lordship, as per the direction of this court, it will again that his present pension will have to be step up, Your Lordship. So that is erroneous, Your Lordship. So the petitioner is not entitled for maximum pension, Your Lordship, to calculate 50% at the maximum of his pension, Your Lordship. So my prayer is that, Your Lordship, the writ appeal may be interfere and the judgment and order dated 10/6/2024 may be question second side, Your Lordship. That's my prayer. Yes.
Yes, Your Lordship. Before approaching this court by way of the petition, my lord, I have represented to the authority. The representation, the last representation is at page 54, man. So basing on by starting from page 54 up to page 61. So basing on my representation, my lord, the authority has issued a letter that is at page 62. Whereby this is dated 2nd March 2022. At page 62, my lord. Yes, may I read, my lord? This is from the Government of Nagaland, Finance Department, Establishment Branch, ROP set, dated 2nd March 2022. This is written to the Principal Accountant General, ANE, Nagaland, Kohima. Subject. Representation against erroneous fixation of revision of pension, family pension of pre-2008 pensioners, family pensioners. Sir, copy of representation dated 2nd December 2021 from Sri Shai Relay, retired Minister Gauhati High Court, Kohima Bench, to salute. In this connection, it is stated that Table 20 of Annex 3 to Nagaland Services Revision of Pay Rules 2010 clearly exhibits the formula for fixation of pay in respect of pay bill 37,400 to 67,000 with direct pay of 9,900 as stipulated at Rule 8, Sub-Rule 2 of Nagaland Services Revision of Pension Rules 2010, copy enclosed. 2 additional increments at the rate of 3% have been granted to the minimum pay bill at the time of initial fixation in respect of pay scale of 16,400 to 20,900, which is clearly reflected at column 3 of Annex 3, Table 20. The revised basic pay along with progress of pay in the pay bill is reflected at column 4 of the same annexure. Further, Finance Department OM of even number dated 5th May 2017 clearly state that pension has to be fixed with reference to annexure 3 of Nagaland Services Revision of Pay Rules 2010, copy enclosed. It is clear from Para 2, the representation dated 2nd December 2021 and Principal AG letter dated 1st October 2021 that pension is in respect of the retired official has not been fixed in accordance with Table 20 of Annex 3 of Nagaland Services Revision of Pay Rules 2010. As such, it is requested that pension in respect of the retired official be reviewed and be fixed in accordance with Table 20 of Annex 3 of ROP Rules 2010. My lord, in reply to this letter, the AG has written to the authority that is dated 9 June 2022. To the Commissioner and Secretary to the Government of Nagaland, Finance Department, Establishment Branch, ROP Cell, Nagaland, Kohima. Revision of pension, family pension of pre 2008 pensioner as per ROP 2010 rates. Sir, in inviting reference to your letter number so and so dated 2/3/2022 regarding revision of pension, family pension of pre 2008 pensioners, I am to state that table number 20 of annexure 3 of Nagaland Service Revision of Pay Rule 2010 exhibit the formula for fixation of pay in the step of pay band so and so with grade pay of 9,900 and provision of Rule 8(2) of ROP Rule 2010 is related to employees who retired on or after 1st June 2008 and not for the pre-2008 pensioners. The applicant retired on superannuation on 28/02/2005. A copy of the annexure table 20 is enclosed here, enclosed for reference. As per the ROP notification dated 10/8/2010, para 19, pension. Roman 5, the revised pension, family pension in no case shall be lower than 50%, that's 30% of the sum of minimum of the pay in the pay band and the grade pay thereon corresponding to the pre-revised pay scale from which the pensioner had died. The pay scale of the pensioner at the time of retirement was 60,400 to 20,900. The revised corresponding pay scale under ROP 2010 is 37,400 to 67,000 with grade pay of 9,900. Pension as per ROP 2010 should not be less than 37,900 so and so to with plus grade pay 9,900 is equal to 47,300 to rupees 23,650. Further, as per OM number so and so dated 05/05/2017, it is clearly stated that the pension, family pension of pre-1/6/2008 family pensioners as revised with effect from 1/6/2008 in terms of sub-rule 1 of Rule 19 Nagaland Services ROP Rule 2010 as amended from time to time shall be further stepped up to 50%/30% as the case may be of the sum of minimum of pay in the pay band and grade pay corresponding to the pre-revised pay scale from which the pensioner had retired as arrived with the reference to the fitment table and next as annexure 3 to the Nagaland Service ROP Rule 2010 notified by Finance Department notification dated 10/08/2010. This office has revised the pension of Sri retired register as per rating recorder serial number 20 of annexure 3 of government of Nagaland OM so and so dated 5/05/2017 by this office authority number so and so dated 18/4/2018 for an amount of rupees 24,725 with effect from 1/6/2013. It is therefore requested to clarify how the provision of annexure 3 of Nagaland Services revision of pay rules 2010 as indicated in OM number so and so dated 05/05/2027 is applicable to pre-2008 pensioners, family pensioners with illustration for settling pending cases. The matter may be treated as on priority basis. So, Madam, against this letter, the next page, my lord. Page 65. This is dated 5th September 2022. Written to by the Finance Department to the Municipal AG, Nagaland Kohima. Subject: revision of pension, family pension of pre-2008 pensioners as per ROP 2010. Sir, I am directed to refer to your letter number so and so dated 9 June 22 on the subject cited above, and to state that Shri Sai retired Minister, Gauhati High Court, Kohima bench retired after raising the effects basic pay in the case here. Therefore, this is important. Therefore, this pension on implementation of ROP rules 2007 should be fixed with reference to the corresponding pay and not with reference to the minimum of the pay scale.
So you seem to be arguing in a different line than what you.
So, Your Lordship, this is the mistake we have done. So we have clarified, Your Lordship, that is at page 73. here we have clearly stated, your lordship, because there is nothing barred to correct ourselves, your lordship. Page 73. This is, we have written to the Principal Accountant General, dated 21 February 2023. Revision of pay family pension of pre-2008 pensioners as per RP Rule 2010. Sir, I'm directed to refer to your letter number dated 8 December 22 on the subject cited above, and to state that revision of pension of Sri Randi, retired Gauhati High Court has been reviewed. Finance Department OM dated 5/5/2017 stipulates that pension should be stepped up to 50% of the minimum of pay in the pay band and the grade pay, with reference to Annexure 3 of Nagaland Services Revision of Pay Rule 2010. Based on this, the pension of the retired official has been stepped up from rupees 23,650 to rupees 24,795 by your office. Hence, the pension fixed by your office is in accordance with extant orders. However, the effective date of implementation of the revised pension should be with effect from 1/4/2010.
Is this under challenge?
No, it's not under challenge, no.
Because this communication was given only after the filing of the petition.
No, Lordship.
During the pendency of the petition.
Before that, we have already clarified to the government. We refer to the letter that my learned friends referred to. Lordship, can you come to page 84 of the appeal memo? Page 73, letter, which my learned friend just read out, is on the basis of my letter. The clarification, page 84. This is dated 8/12/2022. Lordship, I'll just come to paragraph 3. As per ROP, Lordship has found.
Which page?
Page 84. Page 84. So when the finance department said that it should be from the maximum and not minimum, we have clarified. Page 84. Lordship has found. Paragraph 3, Lordship. As per ROP notification dated 10/8/2010, para 19 pension, Roman 5, the revised pension, family pension in no case shall be less than 50%, 30% of the sum of the minimum of pay in the pay band and the grade pay thereon corresponding to the pre-revised pay scale from which the pensioner retired. So that has been clarified. And your lordship, based on that, the letter dated 24/7/2023, page 73 was issued. And they have not challenged all this, lordship. And lordship, on the basis of this, all these communications, lordship, the authority, the clear copy, lordship, will find in page 82. The authority that has been issued, 18/4/2018. This has been issued. With effect from 1/4/2010. And this is also not under check. Okay, may kindly see paragraph 3. Okay, it's
So where is this annexure 3 of? Which page is that?
That's page 96, but appeal memo, page 96 of the appeal memo.
No, lordship, the ready corner is at page 51. Page 51.
This is annexure 3.
Yes, this is annexure 3, your lordship. It is that ready corner, lordship.
No challenge is made to any of this law. There are all people for direction to implement. The ROP law, without giving a challenge to all these communications. Whereby it has been fixed or the revised version. No challenge in the review. There's a direction.
Yes.
Yes, Your Lordship, here, this page 51, which is the annexure of the notification dated 20 December 2017. Since my pension was fixed in the minimum as per this annexure, I have submitted the petition, which is at page 56. Your Lordship. In the representation, I have questioned, this is not correct. Basing on my representation, the authority.
Mr. You forget it, what you have done, what he has done, forget all these things.
My lord.
There is only one issue here.
Yes,
Your client had retired in the year 2005.
yes,
At that time, the ROP prior to 2010 was in force.
yes,
So when he retired, he reached the maximum scale of 20,000.
yes,
Thereafter, the government issued memorandum introducing the 2010 revised pay scale, ROP rules, correct?
yes,
Now, ROP rules will be applicable only to the serving employees for division of pay scale. For corresponding benefit to the pensioners, the government has to issue a separate notification, which they have done in this case. In that notification, they have given the ready reckoner in the form of annexure 3, indicating what will be the pension drawn by which category of employee depending on the scale they have done before their retirement. According to that, they have given a figure which is 24,795, and your client is getting that amount. But you want that the pension should be 50% of the revised pay scale. The revised pay scale is applicable to the employees who are in
so my lord, this minimum, this was also taken from the revised pay scale, my lord.
You argue, but
My lord.
legally it's not correct what you say.
No, that's why I have reported to the authority. My reputation they considered.
Forget, the government cannot change the law. If the government, some official has done it also, doesn't
No,
make any
my lord,
difference.
it is based on the document.
Even if the chief secretary wants, he cannot give you the benefit of pay scale for pensioner.
No, no, in the rule it is there, my lord. Rule 19 of the ROP rule that covers the pensioners, family pensioners.
So you will get, you are getting your pension as per the government OM.
No, my lord, this rule, which is.
You are getting pension as per the government OM applicable to pensioners. You want your pension applicable as per the scale applicable to person in service.
No,
Which
my
cannot
lord,
be done.
my lord, since this letter, which is the latest ROP, that is as per 7 ROP rule, 7 Central Pay Commission, my lord, 2017, there it has clearly given the chart table for the retired employees.
Where is
How
it?
much, my lord, that is not on record. But it is, be my lord, if I can be allowed to make submission on that aspect of it, because this is the latest position where it shows the revision of pension for the intervening period from 1984 till 2000.
Where is it shows? Which page?
My lord, at page page 95. This is table number 33. In the first column, my lord, period of retirement from 1/12/1984 to 31st/5/1990. On the second column is pay scale. Then the second one is from 1/6/1990 to 31st/05/1998. The pay scale is on the. Then the third one from 1/6/06/98 to 31st/05/2008. Pay scale is 60,400, 2009.
So there is a stay of the judgment, is it? This judgment has been stayed.
No.
It has been, it has been. So what do you want now?
My lord, the judgment of the single court has correctly decided for me. So I'm not entitled for the minimum. See,
So your case is that either uphold the judgment, or if you want to allow the writ appeal, then give me time to bring an additional affidavit. Is that your argument?
my lord, can to bring it on record, my lord, is
No, you
This
can't
fact.
make this argument. You have argued the matter, now we'll deliver our judgment. You should have said that in the beginning. After hearing the matter for more than 1 hour, now you want adjournment to bring this on record. That can be done. You conclude your submission, we deliver the judgment.
So my lord, your lordship, may kindly see at page 31 of the appeal memo.
Yes. Yes, please.
This is the rule 19 of the ROP rule 2010, where it mentioned about the pension. And it's rule 1, revised pension, family pension. A, pension to be paid at 50% of the average emolument, last pay drawn, which is more beneficial. My lord,
The last pay drawn was 31,350.
so my lord, but in the ROP, my scale is revised. So my scale is revised.
Correct. Yeah, okay. Yes, anything else?
My lord. Otherwise, my lord, the new facts with regard to the result.
Yeah,
drawing of
these
pension.
are a bit complicated. Forget the ordinary citizen, even the government officials sometimes find it difficult to understand. But then as judges, we'll have to.
But even the rule that Parliament has relied, it speak about minimum,
No, that rule will not be dealt with. It's not a part of the record.
and they have not put a challenge to all this, the order.
You have already said, why are you repeating? Yes.
My lord, I make my submission, the decision rendered by the single judge according to the facts and accomplishment of the case and based on the rules. My lord, even in their particular official, in one point they said that ROP 2010 is not applicable in my case. They have worked out the revised pension as per the ROP 2010. My lord, that is the conflict. In one way, they say, I'm not coming under 2010 rule. Then again, my fixation to the minimum is done under ROP 2010. We are conflicting submission. Whereas, that's why I have approached to the authority. The authority has correctly decided. And basing on that decision, even the London Single President decided the better in favor of the petition. As per the rule, as per the OIL. There is no infirmity in the decision of the rendered by the London Single President.
Yes, that's all. So we'll reserve, you take down, but Ms. V. Shukri, learned additional age. Then for the appellants. So heard Mr. M. K. Wickham, learned counsel representing the restaurant number 1. Mr. M. Modi, learned counsel appeared to the restaurant number 7. Arguments concluded, judgment reserved.
Obliged.
Please, your lordship. Lordship, I would like to mention, item 12. That is hearing.
Item?
12, 1, 2. Lordship, this, matter has been wrongly listed. On 11/4/2025, His Lordship, the Bashir Bora has, ordered to be listed on 24, that is tomorrow. So this is wrongly listed.
Item 12, you're right. It is pointed out at the bar that this matter has been wrongly listed for hearing. This should verify and list the matter accordingly.
Obligation.
May I please, your lordship? My lord, allow me to move one unlisted and distributed bail application as the last item, my lord. My lord, this is the one that I have mentioned yesterday also. And then, your lordship has asked to move it this, today. However, I have filed in the, afternoon yesterday, but it's not in the list, so I will allow to move.
Where is the mentioned memo?
I have.
You have not given it yesterday, mentioned memo.
No, my lord.
You should have given it, then it would have been listed.
Yeah, my lord, I.
Now it
my
will be
apology.
listed tomorrow morning, 10:30 a.m.
My lord, the same section and this.
You should have given the mentioned memo. Why you didn't give it? How will the registry?
I was of the opinion that it will come out in the list.
How will the registry know? I have to go and tell them. Then you have to give the memo.
My lord, my apology.
Give it, we'll see. Yeah, otherwise tomorrow morning first.
Like,
That please, your lordship. My lord, I pick commission item number 1, admission. I have yet to receive the instruction, so kindly give me 3 weeks time to file the positions.
Mr.
That can only my lord.
lordship, I may also be allowed to file a reply to the contract filed by the state respondent.
Register, my lord.
Submit that we yet to receive instructions. Therefore, we granted 3 weeks further.
Lordship, I'm for respondent number 6.
Mr.
Kenyamush.
Also is present for respondent number 6. Learned counsel for the petitioner, Mr. You have to speak, Mr. Chengmai Ponyak is present and does not have any objection there in the law. In view of the above, let this matter be listed again after 3 months.
My
For admission.
lordship, I pick to mention item number 17 to 22. Lordship, they are all analogous matter. Lordship, in this case, I may be allowed to file my reply to the additional affidavit filed by the respondent number 6, lordship. Lordship, may kindly grant me 3 weeks time, lordship.
All right, Mr. Chengmai Ponyak, learned counsel appearing for the petitioners. Batch of petitions submits that 3 weeks time be granted for his clients to file.
Reply to the additional affidavit filed by the respondent number
Additional affidavit is filed by the report number 6. Since the prayer is not objected. Objected to the same stand allowed. Let this matter be listed again after 3 weeks.
Margaret.
May I please, your lordship. Lordship, I'd like to mention item 10. And for the state respondents, I pray for 3 weeks to file my affidavit in opposition, your lordship.
Prayer of learned government advocates. 3 weeks time is granted. Filing. Mr. You have Mr.
W. Armundi, for the petition.
W. R. Nogelu, learned counsel is present for the petitioner.
Oblige, your lordship.
Lordship, I beg to mention item number 16. My senior is indisposed, so kindly this matter may become out after 3 weeks.
Prayer of learned counsel.
Oblige.
May I please, lordship, my lord, I beg to mention item number 11. I'm mentioning on behalf of S. Subhangnacham, my lord. I'm informed that she is yet to receive instruction, so kindly allow 3 weeks time to file everything.
Prayer of learned government and state of Maryland. Let us.
Much obliged.
That is the motion. For the relation of the number of people. Your Lordship, when the matter was referred, the said respondent has filed an additional affidavit, and for that, we have received information to file a reply.
The pair of Miss, your name please? The name? Item 15. 15 connected with this no. This council and a council for the petitioner. Matters stands adjourned for 3 weeks or to enable her to file reply. Additional filed by the response number. Who has filed the additional response? For the state. By the state respondent. Mr. Council and additional state of Nagaland and Mr. Mohajali, then will come for response number 23 and present and do not have any objection. One, three, four. And you have 4? No. Why you said 2 and 3? That much will fear on to which I know. So respond number 2. Yes. 4, 5, 8. 4, 5, and 6. Who is for 1?
We did go.
And so and so for 2 and so and so for 4, 5, and 6. And then we will come.
The living country from Gauhati, so does not appear to be in the lordship. Finally,
Citing the ground of non-availability of the arguing counsel, a prayer for adjournment has been made in this case on behalf of the petitioner. If the prayer is not opposed, since stands allowed, it's the matter again of the
your lordship is a fixed day to be considered from the living country.
You write,
May 19,
request of the petitioner's
19 May,
counsel,
your lordship.
that this petition be discussed on 19/5/2025. Yes, sir.
May I bless your lordship? Your lordship, I beg to mention item number 8.
Item number?
8.
Yes, what do you want?
Your lordship, we have received a counter affidavit filed by the state respondent, so we won't be finding our reply. So I pray the media will receive next Tuesday as fixed item.
You will find reply. Not a file
Your
reply.
lordship, we won't be finding our reply.
You want the matter to be fixed next week.
Next Tuesday, your lordship.
On the request of Miss
Sick move.
so and so, I am counsel for the petitioner. Let this matter be listed again on next Tuesday, that is what is the date? 29th of 2025. As a fixed item. You are present, Miss
Inahuli, your lordship, for all the state respondents, your lordship.
Regina Holly, learned government advocate, Nagaland, is present on behalf of the respondents.
Bless you.
Bless your lordship.
Lordship, I beg to mention item number 3. Here, I'm yet to receive instructions, so kindly grant me 3 weeks time to file my affidavit.
The pair of Miss
AIME.
AIME, learned GA. Nagaland, Manchester, and for 3 weeks. So they will not-
Much obliged. May it please your lordship. Your lordship, I beg to mention here in item number 13 and 14. Your lordship, I pray this matters be listed after 3 weeks.
No objection.
No.
On the pair of Miss Ramesh.
Terry.
Terry, learned counsel appearing to the lead petitioner in both the petition. Hearing of the matter, these matters stand adjourned for 3 weeks. You are for, who is for who?
For the government.
Miss
S. Mary.
Miss S. Mary, learned government advocate, who is present on behalf of the response numbers.
1 to 4.
1 to 4, and you are for?
Lordship, I'm standing on behalf of my senior Joshua Chagis, standing counsel of AG, respondent number 5.
Miss
K. Lily Sue.
Lily Sue.
Yes, Lordship.
Is present on behalf of the response number 5.
Yes.
Like to mention.
Something is left in the list.
Item 4, my lord.
Item 4, yes.
The government is under active consideration. However, I'm yet to receive instructions. May I pray that 3 weeks time may be allowed? Will be some time.
Advocate General, the government of Nagaland prays for 3 weeks further time to obtain inspection and file affidavit. Miss
Our Mayor, Lordship, for the petition.
R. Mary, Senate Council is present for the petition and does not have any objection. There is a. In view of the above admission hearing of this case, is adjourned for 3 weeks.
Much.
That's law. Lordship, I'd like to mention item number 9, at least.
Item number 9, yes.
Well, I have taken the concerns of the parties that let this matter come up on 15, Lordship, please.
On the joint request to learn concept of both the sides, that this matter is for admission hearing again on 15/5/2020.
Lordship, I'm for respondent 5 to 11.
For the state. And for the state.
Give your name, please, Ms. So-and-so, Learned Council and government advocate. Avalanche is present for the small numbers.
1 to 4.
1 to 4 and Mr.
5 to 11, Lordship.
5 to 11. So, your name, please.
Kanyang Shu.
Your Mr.
WR me. For the petition.
On the prayer of Mr. W.R. Nogeli, not of both sides. Right, then what else? Anything else? Yes. There are 2, 3 cases. Anybody is mentioning?
Much obliged. Like.
You want to mention something?
No, I'm waiting for the turn, my lord.
You're
I don't know, I don't know number 2.
I don't know.
For admission, item number 2.
My lord, here I'm agreeing for response number 6 and 7. And my lord, here, response number 7 has directed the LRSO to conduct the verification, but till now the LRSO has not submitted the report. So kindly allow me 3 weeks time to submit the report, my lord. And to file affidavit.
Lordship, I have no objections.
All right, Miss
And Solo.
N. Solo, Learned Council is present for.
If I may, my lord, I'm appearing for CGA CYP Gupta, the counsel for respondent number 1 to 5. In the first week of April, he had filed the affidavit, but unfortunately, he could not serve the copy of the affidavit to the petitioner and respondent number 6 and 7.
Mr. Your name, please.
Pakin Rizal, my lord.
Working Rizal, Council appearing to the respondent number 1 to 5 submitted that no copy of the affidavit filed on behalf of the state. Served up in Mr.
E.T. home.
Yes, sir.
Learned Government Advocate,
Yes, sir.
State of Nagaland, pays for further 3 weeks time to obtain the report. All for. Since it before the court. He has also assured that copy of the counter record will be served to the council for the petitioner as well as the response number 1 to 5.
Your Lordship, respondent 1 to 5 has filed and has not served us the copy.
They have filed. There's number 1 to 5 has filed affidavit, but they have not served us the copy.
Why are you complaining? You want to serve copy?
Yes,
Yes, my lord, I'm asking for time.
Counter affidavit can be filed on behalf of the number 1 to 5 and will be served on. In a week.
Your Lordship, there is an Indian.
In order pass the vote.
Much obliged. For admission, item numbers 5 to 7.
Your Lordship, I have instructions from the PNR department that in all these three repetitions, the petitioner's case, if they were appointed prior to 6/6/2016, then they will be covered by the OM dated 5/3/25, Your Lordship. So if these three repetitions may be disposed of accordingly.
Yes, you are appearing.
Yes, my lord.
So same facts, three repetitions, same facts.
Yes, Lordship, the difference is, just a slight difference is that the petitioner in item number 5 is yet to retire. The other two petitioners have retired.
Right. No. Separate orders will they will make that change. In item 5, right, the petitioner hearing was appointed as a contingency of this peon on fixed wages of rupees 450 per month under the establishment of planning and coordination, bracket, planning machinery, bracket, wide order dated 25/7/1990. Thereafter, in terms of order dated 19/5/2012, the read petitioner, along with the other similarly situated employees, were granted pay bail. System. Grievance of the petitioner is that even after completing 30 years of service and despite repeated requests made by him, the respondents have failed to consider his prayer for regularization of service and also for extending him the benefit of regular pay scale as per the division of pay of 2015. Petitioner continues to work on the fixed pay scale even till today. Therefore, he has approached this court by filing the instant writ petition, seeking a writ of mandamus, directing the authorities to regularize the service of the petitioner and also to extend the benefit of regular pay scale to him. In terms of the order passed by this court, is AIME landed government advocate of the state of Nagaland has obtained written instruction issued by the Undersecretary to the Government of Nagaland dated 15/4/2025 and produced the same before the court. A perusal of the written instruction dated 15/4/2025 shows to show that the government has accepted the claim of the petitioner and two other petitioners. That is the petitioner in WPC number so and so and so and so with the other names. Changing. by projecting that the petitioners who were appointed on contingency basis prior to 6/6/2016 will be covered by the notification number AR dot legal dash dot stroke legal dash 5824 dated 5/3/2025. And hence, they will be granted scale of pay as per the revision of pay number 2015, subject to fulfillment of conditions laid down there. This I may submit that the rate petition can be disposed of in terms of the written instruction dated 15/4/2025. Miss, your name is?
Mika, H.A.
Miss
Mika.
Nika, and a counsel for the petitioner has also agreed such a request. In view of the above, this writ petition and as agreed to by both the sides, this writ petition stands disposed of by directing the respondents to examine the case of the petitioner and pay him the and grant him not him over the and grant her the benefit of pay scale as per revision of pay conducted in 2015. And the decision be implemented as expeditiously as possible, but not later than 3 months from the date of receipt of a certified copy of this order. The above of the copy of the written instruction dated 15/4/2025 be retained in the record of this case. The above observation is a petition further. There will be minor changes in other two matters. The petitioners have since retired from service. So retirement from service is with respect to
Petition, WPC,
6 and 7.
yes, Lordship,
6 and
176 and 178, Lordship. That is item 6 and 7.
These two they have retired from service. This will get on the synopsis. Pointed at what. These are disposed of. That's all.
Much obliged, Lordship.
Give the name, otherwise how I will give you only the order. No, I'll give you the name so we can write it down. That should be on this message. Write it down for you.